Okay, it's about 2:15. The live stream was supposed to start at 2 o'clock from the legislature. It still has not started. So we're just going to, so people know that the stream is coming, we're going to go ahead and start it now. And we'll just put it on pause and wait and see what happens. But Medical Affairs Subcommittee, Senate Bill S-232, which is the Unborn Child Protection Act, was supposed to start at 2 p.m. and no, not taking any public testimony, just dealing with the bill and any amendments they want for the bill, and then voting on it, and I guess hopefully moving it to full subcommittee. So we'll go on pause for right now. I will put a note that we're waiting for the stream to start, and we'll be back in.
You can't take an HCG test for clinical diagnosis that's going to show up until sometime close to a week after implantation. There are no forms of birth control that will terminate a child a week after implantation, including Plan B.
That makes more sense to me. So what it does effectively is it realigns the current prohibitive timestamp of when abortion would be considered legal.
Currently, the law would not allow a physician to perform an abortion without checking for a heartbeat.
Sure.
If the unborn child has a heartbeat, then you cannot kill it. That's the line of demarcation. You can't take the abortion pills to then kill the unborn child. Clinically diagnosable becomes
From
the
that
line.
point. So it moves the point from 6 weeks to whatever that is. That not accurate?
That is
Okay,
accurate. I
okay.
think that's a good way to understand it. It moves the line to when a pregnancy is clinically diagnosable, which
Okay.
I have said is about a week after implantation.
Excellent. All right. Thank you, Mr. Chair.
All right, so back to the amendment. I'm at the top of the written copy, page 2. The next line there says, amend the bill further, section 3, by striking section 44, 41, 615D, and changing the language a little bit. And the language I have changed is to add a phrase to the end of that prohibition against recruiting, harboring, or transporting a pregnant minor to another state to procure an abortion or to obtain an abortifacient. And what I have done is simply add the words at the end of that sentence, without the consent of one of the pregnant minor's parents or legal guardian. Any questions about that? All right, then moving on to section 44, 41, 640F. If you were at the first subcommittee hearing, you might remember one of the doctors testifying about the about section F, which is in the case of a non-emergency premature delivery after 19 weeks of pregnancy, and then there's a whole several paragraphs there. And basically, after listening to her testimony and talking with other people further about that, I've just come to the conclusion that that paragraph is better just being deleted in its entirety, which is what I've done. Okay. If there are no questions about that,
Mr. Chairman.
yes, sir.
Mr. Chairman, so in section 3, we just added an exception to, I'll call it the non-transport or I'll just call it the non-transport clause, where if one of the minors' parents or legal guardian gives consent, then it's permissible. Is that correct?
Correct.
All right, and then we go to the next section, and then we talk about a plaintiff who is aggrieved and brings an action. So in a scenario where, let's assume hypothetically that the mother is the custodial parent, and the father is the one who's a non-custodial parent who transports or permits to transport. Can the mother be a plaintiff?
I'm sorry, where are we at in asking that question? Are you talking about the civil action farther in the bill?
No, right after, in your amendment, we deal with section 3, subsection 2, which is the one that you added without the consent of one of the pregnant minors' parents or legal guardians. And then the next strike after that, which is section 3, subsection C, is where we talk about the civil causes of action. You with me?
It goes from 640 to 660.
Yeah, you're jumping.
This is 615.
Yeah,
This is 660.
but isn't that the next amendment that we're talking
It
about?
is the next amendment,
Oh,
but it's not the next
one.
section.
Yeah,
Yeah.
okay.
Yeah, so I'm just going by the screen. Which
That's,
just kinda
that's fine. You're
highlights-
just moving on to the next amendment.
Yes, sir.
Okay.
Okay.
I think I understand what you're saying. So, if you could restate the question.
Sure. So we just indicated that one parent when we look at, and I apologize, I should have stated for the record that I was talking about section 44, 41, 660C. A non-consenting parent have a cause of action.
I think the non-consenting parent would have a cause of action.
So we give permission, we give the
it's a civil cause of action also to grandparents. So just because
Their parent, yeah.
gives consent,
Yeah.
that does not remove the rights from others who are biologically related to the unborn child who's being killed from bringing a civil cause of action. The father, in your scenario, if the father's not giving consent, if the father is opposed, if the father has suffered the loss of his grandchild against his wishes, then he can bring civil action, I believe is the way it is written.
Yeah, no, I mean, it's just kind of unusual that we would say this, that an action is lawful, but then we give the right to somebody else to sue somebody for committing a lawful act. It's just, it's contradictory, in my opinion, Mr. Chairman.
Well, I don't think it's contradictory because there are many people who have interest in the life of the unborn child. And the laws, I think, allowing those people to have a cause of action. But, you know, some of this code, as you can imagine, is code that is drawn upon from other places. I think this was probably, well, I don't think it was in the heartbeat bill. And it's in this bill. And, you know, before that, I think this idea, so to speak, you know, probably started with legislation in Texas.
Mr. Chairman, I just state that this, when we compare this one to the heart bill, this one reaches far beyond heartbeat bill. This one reaches far beyond in a number of aspects. But thank you for asking my question.
Mr. Chair.
Senator Johnson.
Thank you. Just following up on Senator from Williamsburg's point, and I think I didn't see that really until he pointed it out, but it to your point that it's not contradictory, it's essentially bad law because you're telling the mother that you can consent to transport your minor child to North Carolina to receive an abortion. And then we're telling the grandmother or grandparent or whomever may have an interest that we just enabled by law the mother of the minor child to take her daughter to North Carolina. But then we, by law, set her up to be sued and have to go through strenuous litigation, attorney's costs, all of that for something that we told her and enabled the mother that she could do. I think that's, if my opinion would be, if that's the case, it's so contradictory. You shouldn't even offer that to legal, to say you can lawfully do something, but by the way, you potentially can get sued, although we're authorizing you by law in South Carolina to do that. How is that not contradictory or bad law?
Well, going back to the prior amendment about recruiting or harboring or transporting a minor.
Right. Because initially it was, you couldn't do that at all, right?
You couldn't do that
Right.
at all.
And
but
what you're trying to offer
I
is
think
to allow it.
in my further study that you constitutionally can't prohibit someone from traveling to another state. Okay.
That's
But
correct.
now I'm trying to make sure the child's not being trafficked, that someone's taking that child without the minor, without a parent's knowledge or consent across the state line for an abortion. So that was the first change.
Right.
Now,
And that's okay
the second,
if you remove the part where you can, then somebody else can go sue.
well, the second part about the suing, as I said, is already in the code. I don't see any reason to remove it. I will say this, if you read section 660, it does say no one who aids and abets an abortion may bring a civil action under this section. And I don't think that was originally in the code. But I certainly don't believe if you're aiding and abetting, you can bring a civil action. But a grandparent who's unaware, I I think can. So that's my position. I mean, I've tried to answer your question as best I can. All right, so we're in that section now, 660. I've made a couple of changes there. You see them there in blue. I will say this under point number D. I added that language as a result of the testimony given by one of the attorneys who opposed this bill, who in his opposition claimed that the way it was written, that the father of a rapist could sue for civil damages. And so I've never heard of that happening. But I put in a few extra words to say if you've been involved in criminal sexual conduct or someone related to you, you know, can't bring this action. So I did listen to the testimony. I have reviewed the testimony. The change I made about going out of state, this change, I mean, those are just results of people, what I would say, you know, pointing things out that perhaps it never occurred to me, but just trying to satisfy their concerns in that regard. So that is it. That is the last of my amendment. Are there any further questions or discussion upon that amendment? Is there a motion? Okay. Motion has been made. Is there a second? And a second to adopt this amendment. If there's no further discussion, we'll go to a vote. All those in favor, if you'd please raise your right hand. Five. Okay. All those opposed? Okay. The amendment passes 5-4. Yes. Okay, this amendment is by the senator from Greenwood. So at this time, I will recognize him to explain the amendment.
Thank you, Mr. Chairman. Mr. Chairman, after much deliberation, I have decided that, for my constituents at least, that we're in a situation where we just cannot, it is not proper in our estimation, to create criminal laws to punish our pregnant women or any of our women in South Carolina. So this amendment basically abolishes any type of civil or criminal penalty against the woman in this setting. I can go into detail as the thoughts behind that if the committee would like. Otherwise, it's pretty straightforward.
All right, so I will elaborate on the change just a second, if you don't mind. And the bill as proposed, anyone participating in the killing of an unborn child, including the pregnant woman, would be guilty of a felony and upon conviction must be imprisoned for not more than 30 years if the unborn child dies as a result of the violation, or for not more than 25 years if the unborn child is born alive despite the violation. So that is the way the bill was drafted. The proposed amendment for the pregnant woman says that she would not be criminally prosecuted for any violation of the section. Is that correct, Senator from Greenwood?
That is correct, criminally or civilly.
Criminally or civilly. So that is the proposed amendment. Now, we're going to have some discussion about this amendment. Senator from Greenwood, would you like me to go ahead and express my thoughts, and then you can respond?
You're the chair. I'll do what you want to go first, or I'll be
Okay.
happy to expound just whenever you're ready for me to expound upon the subject.
That's fine. I think it'd probably be best if I just go ahead and state my opposition to this amendment. Let me preface that by saying that I have admiration and love for the senator from Greenwood. We disagree emphatically over this amendment, and I'm going to express my opposition to it. It's going to take a few minutes. In my opinion, this amendment, if it's adopted, will gut the bill. And I want to do this as charitably as possible, and I'm sure he will respond in kind because we have been the bills on the floor during the special session. I don't think there was anyone who spoke more often or more passionately than he made against this. Just yesterday in Rock Hill, South Carolina, there was an incident where a 20-year-old woman has been arrested and charged with attempted murder after authorities say she induced labor at 27 weeks and failed to seek medical help for the newborn. So she knew she was far along in pregnancy. She didn't want the baby. She induced labor to try to have an abortion and was unsuccessful insofar as the baby was born alive. At that point, she did not seek, the article says she failed to seek medical help for the newborn and has been charged, as the article says, for that. And the reason I draw your attention to this incident is because it highlights in such a stark fashion the glaring inconsistency not only of our law, but of the varying pro-life positions on whether a woman is legally accountable for her own actions in regards to trying to kill her unborn child. As far as I understand the code and all the relevant codes surrounding this situation, she took drugs to induce an abortion, and if she had been successful, if the child had been delivered dead, there would be no held criminally or civilly liable for taking part in an abortion, even a self-administered abortion. Same baby, born alive By failure to render aid or seek help, she's facing a legal charge. Because somehow magically, when the baby is born, it achieves some kind of status that it didn't have 5 minutes before birth if it had died as a result of the drug-inducing medications. That's the glaring inconsistency of our law in its current state, is that somehow the unborn child has no legal status of protection from his or her own mother. But if the child is born, now all of a sudden magically it achieves some extra status of humanity that it didn't have if the mother had been successful in the attempt to abort the child. So when we as a society get away from the commandment, thou shalt not kill, this is where we end up. When we get away from imposing penalties on everyone who participates in the killing of an unborn baby, this is where we end up. In 2023, we passed the heartbeat bill, and all the pro-life people rejoiced, myself included. Although we had failed by a few votes to pass a much stronger law, and although that was terribly grievous to me that we failed in that attempt, nevertheless, we rejoiced and believed that the heartbeat law would save thousands of lives every year, literally. But I had a deep concern about the heartbeat bill, because during the debate, we passed an amendment which removed an already existing penalty in the South Carolina Code for self-administered abortions. In other words, in the midst of passing the heartbeat law, we took out some existing code that was a penalty for self-administered abortions. I spoke against that amendment before making a tabling motion, which failed. And I want to read you a few brief quotes from my floor speech on that day in 2023. Quote, I'm not one of those who agrees that there should never, ever be a penalty for a woman who has an abortion. I believe we are all moral agents. We are all accountable for our actions. So just on that basis, just on the basis of that alone, I would say, how can you have a law that criminalizes some action and then say, but if you break the law, there's no penalty? It's not even logical. Further on, I said this, quote, this amendment relates directly to an aspect of the abortion issue that is rapidly evolving, and that is drug-induced abortions, medication abortions. Recent statistics have shown a decline in surgical abortion and a rapid rise in drug-induced abortions. In 2019, that became 61%. 2020, that became 67%. In 2021, of the total of 6,279 abortions recorded by DHEC in this state, 4,623, 73% were done by medication. They were drug-induced abortions. 73%. So in a period of 4 years, it rose from 55% of all abortions to 73% of all abortions. So this leads me to the main point. We delete this section of the code, it's going to incentivize do-it-yourself abortions at home. End quote. Final quote from 2023. I am convinced this amendment would have the unintended consequence of creating a market or an incentive for self-induced home abortions whereby there's no penalty for the woman to go out and try to find the drugs however she can, whoever is selling them illegally, and doing the abortion at home, because there's no penalty if this amendment was adopted. End quote. In 2024, the South Carolina Department of Public Health reported a total of 3,025 abortions. Now, keep in mind that the last year prior to Roe v. Wade being overturned, this state recorded 6,279 abortions. But in the year after the heartbeat bill was passed and was fully in effect, 2024, the number fell to 3,025. That's a pretty good sized drop. So it appeared that the heartbeat law had reduced the number of babies killed by abortion by about half. If only that were the case. Although I believe the heartbeat law has saved some lives, over the past year, I've had to come to grips with the reality of mail-order abortion pills, especially in light of the fact that 84% of recorded abortions in South Carolina in 2024 were done at home using abortion pills. So we went from 55% in 2018 to 84% in 2024. Of all abortions recorded in this state were done at home using abortion pills. Did you know that mail-order abortion drugs are tracked by both the Guttmacher Institute and the Society of Family Planning, who conducts a project which is called #WeCount? According to #WeCount, 3,890 South Carolina women were mailed drugs from abortionists in shielding states. Now, that just simply means that if New York has a law that says their abortionists can mail pills, then they're shielded by that state from any liability for mailing pills to states such as South Carolina. The members of this committee received a handout at the first subcommittee meeting, and maybe you looked at it and maybe you didn't. I'm going to give you another copy to look at. Because basically, it takes into account the fact that telehealth organizations, abortionists, are tracking where these pills are being mailed. There are studies that have been done on the percentage of abortions that are completed using pills, because people are so interested in knowing this information. And studies show almost 90% of the people who order these pills do in fact use them to have abortions. So if you're looking at this page, there's a number there at the top right, 3,423 is the estimate of how many abortions were done in South Carolina using mail-order abortion pills. In other words, a number that is greater than the number reported by DHEC, because these abortions aren't counted by DHEC because DHEC knows nothing about them. The pills just go straight to the person's home. These numbers are also being reported on by the Charlotte Lozier Institute, which is the research and education arm of the national pro-life group, the Susan B. Anthony List. This isn't made up data. I could provide you with a paper from the Charlotte Lozier Institute discussing all these statistics I'm rattling off to you. I will tell you, when I first came into possession of this information about mail order abortion pills, I didn't want to deal with it. In fact, it made me angry, and I wanted to throw the information in the trash because it calls into question the efficacy of the heartbeat law. It calls into question how many babies are actually being saved, and I didn't want to hear it. But then I remembered my speech. I remembered saying that removing the penalty for self-abortions would incentivize do-it-yourself abortions at home. It's just logical if there's no penalty. And so here we are. There are many problems with this amendment to give mothers complete immunity for killing their unborn child. Here are some of the problems, besides what I have already stated. We had a constitutional scholar speak on behalf of this bill in the first subcommittee, someone who deals with this issue at the level all the way up to the Supreme Court, Steve Crampton. He made this comment in his testimony. There is some concern raised by even pro-life groups that holding mothers accountable for their part in aborting their own unborn children is somehow an egregious wrong. I would respectfully suggest that it is in fact just and logical to extend the full protection of the law to the unborn, especially in a day like we find ourselves today, where abortion is no longer only rendered in an abortion clinic or facility. In fact, mothers all over the land now have access to chemical abortions, abortifacients, and can conduct abortions in their own home. If we fail to extend the protection of the law to the unborn as it pertains to mothers, then you really have an unequal protection of the unborn across the board. Only those who are taken to the abortion clinic are protected. Those who remain at home and let the mother proceed are left unprotected. That is unjust, and it is frankly a violation of the Equal Protection Clause. So his testimony to us is a bill that gives complete immunity to the mother, thereby not protecting the unborn child from its own mother, is a violation of the constitutional Equal Protection Clause. That was his testimony. It is already in our code, Title 16-3-1083. If someone were to assault a pregnant woman, a stranger assaults a pregnant woman, and the unborn child was to die as a result of the assault, the person committing the assault could be, if the woman also died, would face 2 counts of homicide. In that case, the unborn child has the same status, the same value under the law as the mother herself. But it would appear on the basis of current law that the value of the unborn child depends solely on whether that child is wanted or not by the mother. If the unborn child is wanted and a stranger kills the child, a homicide charge can be made. If a mother decides to take abortion pills to kill her unborn child, she is explicitly immune from any legal accountability. So I ask the members of this committee, is that what we believe? That the intrinsic humanity and worth of an unborn child created in God's image rests solely on whether the mother wants the child or not? Some people have said that the penalty I put into this bill is too harsh. The penalty in the bill is up to 30 years for killing an unborn child, but you will note that there's no mandatory minimum in the bill. A judge and a jury get to decide that. If someone was found guilty of participating in the killing of an unborn child, they could get 1 day or they could get up to 30 years. That is what a judge and a jury in a courtroom is for, to decide the matters of fact and to apply the law. I've had to think about this a lot. When I made my comments on the floor in 2023, trying to stop us from removing the penalty for self-administered abortion, I didn't take any questions. But the senator from Richland followed me and he asked a question, and it was a good question. The question he asked was, what do you think the penalty should be? What should the penalty be for a mother who participates in the killing of her unborn child? That's a fair question. When I drafted this bill, I put in up to 30 years. And I've had to think about that and reflect on that for almost a year now. I'm still thinking about it. So here's a few things that I've had to think about. A person who tortures, torments, needlessly mutilates, cruelly kills, or inflicts excessive or repeated unnecessary pain or suffering upon an animal, or by omission or commission causes these acts to be done, is guilty of a felony, and upon conviction must be punished by imprisonment of not less than 180 days, and not to exceed 5 years, and by a fine of $5,000. So cruelty to animals will get you, if you're convicted, a minimum of 180 days, up to 5 years, and a fine of $5,000. Even the penalty in our current code for those who commit a surgical abortion is not that harsh. I believe the penalty for committing the surgical abortion it could be imprisonment for a term of not less than 2 years, nor more than 5 years, or fined not more than $5,000. It's an either or. The law could just get a $5,000 fine or up to $5,000 fine. Animal cruelty, you get a mandatory minimum of 180 days and the fine. I'm not talking about what punishment for the woman. That's for the abortionist who commits the abortion. Has a lesser penalty than the person who commits and is found guilty of animal cruelty. Because we're so afraid to put a harsher penalty in the code because the medical doctors will rise up against us. So is that what we think of the value of the unborn child? Less than an animal. Other relevant code sections and penalties: manslaughter, unlawful killing without malice. It's a minimum of 2 years up to 30 years, which is a harsher penalty than I put into my bill. That's manslaughter. Homicide by child abuse. Causing the death of a child under the age of 11 while committing child abuse or neglect, and the death occurs under circumstances manifesting an extreme indifference to human life, 20 years to life. Homicide by child abuse, 20 years to life. So what's going to be the result of this amendment? There will be no respect for the law where there is no penalty for breaking the law. A law without penalty has no teeth, no deterrent effect. It will be considered a suggestion and nothing more. It's like telling people don't speed. But if you do speed, there's no ticket, ever. In that case, what's the difference between me going 65 and 85? There is none. You can make the law and say don't speed, but if there's no penalty, people are going to do what they want to do. And in fact, under current law, killing an unborn child by taking abortion pills will actually have less penalty than it has no penalty at all. It's completely upside down. A second result of passing this immunity is that all the pro-life arguments regarding the sanctity of life of the unborn child will be greatly undermined. To loudly proclaim the inalienable right to life of the unborn child, while simultaneously proudly and loudly proclaiming that the mother who kills her unborn child has no guilt before the law, is not only inconsistent, it is not only illogical, it is incoherent. You simply cannot make sense of that position. The Bible tells us to rescue those who are being carried away to death. I am trying to save innocent unborn babies by passing a law that will deter people from killing unborn babies. And I would ask my fellow senators this: will this bill save more lives by giving mothers complete immunity to kill their unborn babies, or by retaining a penalty that will act as a deterrent and send the message that unborn babies are indeed fully members of the human family? That is the point of the bill. For a long time, we've not even had to think about this conversation. Until Roe v. Wade was overturned, pro-life effort in the policy domain was aimed at producing a bill that would create a legal challenge to overturn Roe v. Wade. I was the prime sponsor of the personhood bill in 2018. Why? We wanted to give the Supreme Court a bill about personhood that would cause them to revisit the question about personhood in the hopes of them changing their mind and overturning Roe. When I was drafting that bill, when we were debating that bill, we weren't talking about should the woman have a penalty for killing her unborn child, because that was so far removed from the conversation at hand, which is, what can we do to get the Supreme Court to revisit the fundamental issue of what is an unborn child and when does it have rights to life? I didn't know if I would ever live to see the overturning of Roe v. Wade. But because it happened, we now have to face many, many different questions about what the law should say, because we are charged with writing the law. Supreme Court's not writing the law. They've said, let the states write the law. And so I understand why people find this subject in particular so hard to grapple with, because we haven't been sitting around thinking about it for 30 years. We've been thinking about how to get a Supreme Court ruling to overturn Roe. But in writing the law, all of a sudden these questions arise, and I've had to think more long, more deep, more hard in the past few years about something that prior to that really just didn't cross my mind because it wasn't part of the legal strategy to overturn Roe. So I understand when pro-life people say, Cash, you're going too far. We've never believed that. I would say, no, we've never even thought about it. We've never had to think about it. And now we do. Now we do. And what we decide is going to make a great deal in the end as to how society views the unborn child. Because what I'm hearing is, wait, don't do that quite yet. Let's build a culture of life. And someday when we have a culture of life, then it will be okay to impose penalties upon those who get abortions. Well, how long do we have to wait? Is it 50 years until we kill another 65 million unborn babies? How long until justice, or something that even approximates justice, is put into the code book? Because here's what I do sincerely believe. We cannot and we will not build a culture of life when the law reflects that someone who kills an unborn child can have no legal culpability for their moral action. We won't ever get to that point. The law is a tutor, it is a teacher. It tells society what we think about the unborn child. Again, I ask the question, if this bill should pass, will it save more lives by giving a mother complete immunity, or will it save more lives by putting a strong deterrent in the law, something that approximates justice and treats the unborn child as a full member of the human family, just as we ourselves wish to be treated? This time I would turn it over to the senator from Greenwood.
Thank you, Senator Cash. And as you know, I am a proponent of saving children's lives, the unborn lives, especially the unborn innocent lives that have died. The 65 million is what really, breaks my heart. And we're finally making progress. The purpose of this bill, and the reason that I joined as a co-sponsor, is to help save babies' lives. I too believe in the dignity of the unborn. I hope you know that. And I truly believe that they're a blessing from God. And I don't think governments, to be honest with you, have a right to say in the matter at all, because it is a blessing from God that we have children. And so, here we are, and we're trying to decide, what do we do? At this juncture, what we're trying to do is move the debate from 6 weeks out. I'm not in favor of allowing any babies to be killed from the time of conception until the 6 weeks. So I'm probably extreme in that matter, but I'm extreme in favor of saving babies' lives. I'll always be that way. My constituents are that way. They asked me to be that way, and I am. But I have never intended, nor should any of us ever intend to punish or be punitive towards our moms. Here's the thing about criminal law. I've practiced it for 42 years now. And what is interesting about criminal law is that it has to be definite. It has to be certain, and you can't change it based upon a whim. In order for us to respect the law, it has to be constant. So let's look at this idea of punishment. Let's take it back before Roe versus Wade. If we take it back before Roe versus Wade, it was punishment for the doctor. It could be as much as 5 years, mandatory minimum, and more. I think it was up to 20 years. For the mother, it was 2 years or $1,000 fine. But provided that she testify against the abortionist, she was granted complete immunity. So in our law from the 70s, all the way from that time, we provided an immunity method for mothers. Because again, they're in many respects victims as well, especially in a different time in our society. I am concerned that there have been many changes by our government of late. In the 70s, we were told by Roe versus Wade that it's okay to kill your baby. It's a method of birth control. You got a right to do it, kill it, go for it. And unless that child was viable, you could just kill it. And in some states, they've interpreted that to mean that the child could be born. If you didn't like the hair color, you could kill it. In the harsh extremes. I don't believe that we should have a society where we don't know what the law is or it keeps moving. We need to get to a point to where we know exactly what it is. I truly believe, my constituent believes, that life begins at conception. Now, we can't prove conception, and that's when the sperm meets the egg. And I believe there's a light because I believe it's a blessing from God. I truly believe that. Life's a beautiful thing and it's a perfect thing. But we can't prove when that happens. So what's the next best step that we can prove? We can prove a diagnosable pregnancy. Now, scientifically, we can prove that. So if we could bring the time not to have an abortion to end at pregnancy, then we're, in my estimation, we're where we need to be, and my constituents as well. But punishing the mother is a road or a bridge too far, because in our prior law, we didn't do it. Then for all these years, mothers, grandmothers, daughters, sisters, aunts, they've all been told that it's okay, when in fact it was a false doctrine. This Roe versus Wade is a false doctrine. We all know thou shalt not kill. If we look at our Bibles, we've known that since the beginning of time, and our government is based on moral principles. It's designed to protect inalienable rights. The right to life, my friends, is an inalienable right. And I've seen all these statistics and all, but the poor little children who are unborn, who've never had a say, are just as human. And every one of you went through that stage. Every person in this room, every person in the world has gone through the stage of being a human being at the earliest stages of development. And guess what? Protected in mom's womb. And that's the way God intended it. And that's the way we should all honor it, because that's what it is. So we shouldn't kill after that. We should not abort a child after that. Now, all of these abortifacients and all these drugs that people are using, they need to stop. As you know, people, they're licensed people. They understand what the law is. They understand it. They know what it is and what it has been since the 70s. They know what they can and what they can't do. And I'm making sure that this law is telling them that if there is a situation where the mom's life is at stake, that they always have and will always have the ability to take care of that child and the ability to take care of that mother. And if there's a fight between whether or not to save the mother's life or the child's life, then it should be left to the mother if she's able. Otherwise, to the mother if she's able to make the decision. Because the mother has a right to self-preservation. That's also biblical. That has been in our right of self-defense, has been in our law since the beginning of time. So these things that I speak of, think about it for just a minute. First, it was 2 years. Then it was no penalty at all. Then, of course, we had the Pain Capable Act, which said 20 weeks, as I recall. In other words, you couldn't kill a baby after 20 weeks. Pain capable. Then it changed. Okay. Then we had the Dobbs decision came down. In that case, they were looking at another state, but it was a 15-week. So then it went to 15 weeks is what was approved. by the federal courts, but it put it back into the state courts' hands for us to decide. Now, South Carolina is probably going to be more conservative than some of our other. I see this as something very serious. And if it's going to be a criminal act and it's defined, and so be it. As it relates to the doctors, it's pretty clear to me in my review of this bill that the doctors need to take heed. And also these people that are providing these pills, as far as I'm concerned, if you provide a pill to a woman who's expecting and you're not a doctor and you provide that, that's no different than giving them some type of illicit drug and killing them with the illicit drugs. Because a lot of these women, based on the testimony that we heard earlier, unfortunately are taking these pills after they're pregnant, and it might very well kill them, and it may very well kill their child. So that has to stop. And I don't think punishing women is the way to do it. I think punishing those people that send those drugs here is the way to do it. I think that punishing doctors who perform these types of abortions after they know when they can't is problematical. Again, punishing women, in my estimation, is not the way to go here. So, in all due respect and all due candor, I yield back to the chairman, but say this. This world needs more love than hate. This world needs more forgiveness than hate. And we got to work towards that. And I love these babies. I want every one of these babies to live. And I want every one of these mothers to flourish. And I'll be honest with you, we don't do enough in the legislature. And I'm passing a bill or trying to get a bill passed. It's going to be it's going to be something called an ombudsman's bill for women, expected women. And it's going to be able to tell every woman all the things that are available to you in your expected circumstances, as well as your child to be born. We got to do a better job of taking care of the children once they're here. And I want to see the Republican side of this aisle, as well as my Democrat friends who have always been in that regard. Let's make sure that we take care of those folks when they're here. We need to protect all South Carolinians, even the unborn, all the way to the point of conception, if we can. Thank you, Mr. Chairman.
Thank you, Senator. Are there others? Senator Sapp.
Thanks, Chairman. And I listened to both of your comments very attentively. I'd just say a few things and not to give a long speech. But when I think in terms of the idea that as lawmakers, perhaps the whole idea of what to do beyond Roe versus Wade was not contemplated to the point where all answers are known. I think for lawmakers that may be true, but for the South Carolinians who have been living and dealing with family-oriented issues for all of these years, the issue is not new to them and how they've made decisions at the family and with the consult of doctors throughout the years. And frankly, I'll never change from the idea that how we should have moved forward beyond the Dobbs decision should have been left to the voters. We should have put forth a referendum and allow the majority of South Carolinians to help us decide this issue. They're the ones that have been living with it, not just the men in the chambers. And so I think that that it was a flaw. I don't consider it a fatal flaw because we can still cure it, but that it was a flaw in terms of how we approached dealing with the issue as a state, because the issue is so important, and it touches almost every household in the state of South Carolina. That's my first point. My second point is when I hear it said that if you break the law, there should be penalties. I agree with that. If you break the law, there should be penalties. That fundamental notion I agree with. But the opposite ought also be true. And that's why we had the debate on one of the amendments earlier. If you break the law, there should be penalties. The opposite ought also hold true. If you don't break the law, there shouldn't be any penalties. And so there are so many areas of this bill in my mind that are flawed until I view the whole thing as being troublesome. I'd like to make the last point as it pertains to this amendment. It doesn't go far enough. I mean, we heard the testimony of doctor after doctor after doctor that told us about the complexities that are associated with them and these urgent decisions that they have to make day in and day out. And we've created a scenario where they've made it clear to us. Now we have to call our lawyers. If it's 3 or 4 o'clock in the morning, we need to get advice in terms of whether or not we're putting our license at risk and whether or not we're putting our freedoms at risk. We know it. There is no question in the mind of any of us who sit on this panel. We have listened to them. And quite frankly, I appreciate them, because even the ones that were in favor of the legislation, when questioned about it, were truthful and candid. And so there are no mysteries as it relates to the predicament that we're putting these doctors in. And so for the senator's amendment, my friend, to address the issue, I appreciate it, but it doesn't go far enough. We need to deal with doctor criminality as well. And so I'm going to vote against the amendment because I think it needs to deal with both of the issues. It needs to deal with the women and the fact that they ought not be jailed and incarcerated, and neither should it be dealing with the doctors in these difficult situations that they find themselves in. Thank you, Mr. Chairman.
Thank you, Senator. Other senators? Senator from Charleston.
This is more of a question for the attorneys on the committee. I just have this question about, is there any other statute in our canon of law that criminalizes an act and also gives blanket immunity to a certain class of citizens that we, other than the heartbeat bill, that we know of offhand?
In case, Mr. Chairman,
Go ahead, Senator from Greenwood.
in cases of rape of the child, they can't consent in that setting, even though they may have participated, but they can't truly consent because they're not of age. I'm talking about 15-year-olds and that type of thing.
That's more the victim though, right? I mean,
Yeah, it's a victim, but the prosecution, even if they were actually participating in the act. I'm trying to give you an example of what
I think, that is a valid example of a victim not being prosecuted, but is there a situation where we write law and then give immunity to any class of citizen?
Senator from Orangeburg.
We do, under the Stand Your Ground statute, we say that shooting somebody else is a crime unless they're coming in your house.
But we didn't criminalize. I
Yeah,
mean,
we criminalize shooting people.
Yeah, well, sure,
Okay.
but we also are stipulating that is not that crime. I mean, they are literally defending themselves. That's the Castle Doctrine. So
And that is the Stand Your Ground doctrine. They're defending them. I mean, that's self-defense, but the Castle Doctrine is the person coming into your house may not be committing a crime. They could be selling cookies. You still can shoot them because they're coming in your house. I mean, I'm not saying that's a great thing, but you're asking for an example, and we have it's an absolute immunity to use a gun while you're in your house to
I
kill
guess-
somebody coming in your house, whether the person was going to commit a crime or not.
Oh, and that's valid, but we're not saying that women or men.
I don't think that has any application to this. You were just asking for an example. Okay, it's an example, but it doesn't make any sense to this debate.
I think it does because I mean, when I say a class of citizen, we're talking about the woman as opposed to the man. So in your example, the Castle Doctrine, that would apply to both men and women.
It protects gun owners regardless of gender.
Right. Thank you.
Senator from Somerville?
Sure. Berkeley. I want my colleagues on the committee and for those who are listening, know where I am. We were on our way home. And I'm sorry, I'm getting emotional because this is a very emotional conversation I had with my wife. We have 6 girls. And all 6 of my daughters know where I am on abortion. I am stubborn and I am immovable. On the way home last week from a vacation, we were coming up I-95. I got a phone call from a fellow senator, and we had a conversation about this very topic. End of the conversation, and we had some friends in the car. If you can pull my dash cam video and see how long the conversation lasted and how passionate I was, I can tell you right now, I am pro-life. I don't want to see the lives of babies harmed or taken. And then I said very firmly to my wife, and I'm glad my wife agreed with me, and so do our 6 girls. I'm sorry, Mr. Chair. There's nothing against you personally. I cannot see women be put in jail. I can't. If we're going to sit here and continue to talk about women as if they are the worst kinds of creatures on earth, I might as well say that to all 6 of my girls. If we have a mother and a father both mutually agree to end the life of a baby, and we're only going to punish the mother. I am in favor of this bill. I don't want to see babies killed anymore. I don't. And how we reach a point where that can eventually stop, that is such a hard question that I cannot answer. I wish it stopped today. But putting a woman in jail for 30 years, that's where I am. And that's why I support this amendment. Thank you, Mr. Chair.
Berkeley, if I might respond for just a second. This bill does not single out women to be punished. It's very obvious in the bill that anyone who's involved in the killing of the unborn child is legally accountable to the law and subject to the same penalty. The hand of one is the hand of all is the doctrine in play. So I'm not, one of your comments seemed to indicate that if the man and the wife both agreed to kill the unborn baby, then only the wife would be held accountable. That's, if the man's aiding and abetting, he's just as accountable under the law. If someone is coercing that woman to have an abortion, that person is subject to the same 30-year penalty. If someone is delivering the abortion pills to the woman, and it doesn't matter who they are, if they knowingly, intentionally are giving her the pills to kill the baby, that person is subject to the same penalty. This law, I would say that it's actually the amendment that is singling out women because it's saying one person is never accountable in the killing of an unborn child, and that is the woman. Everyone else can be subject to criminal liability except for one person. So I appreciate your comments. Are there other comments? Okay. Well, let us take a vote on the matter. Those who are in favor of the amendment, those who want the amendment to pass, please raise your right hand. Okay. Those who are opposed to the amendment? Okay. By a 5-4 vote, the amendment fails. Okay. Could you go ahead and distribute it, please?
Mr. Chair, I'm ready to explain it.
Senator from Greenwood.
Thank you, Mr. Chairman. In my estimation, your bill, your original bill, was far to the right extreme, was far to the left extreme. Where our history has put us and where our pre-Roe law was by legislators who were here before us, they set the penalty for the woman at in a fine and amount not to exceed $1,000, and it's a misdemeanor as opposed to a felony, or imprisonment for not more than 2 years or both. However, it also provided a pregnant woman on whom an abortion is performed or induced, and abortion is attempted to be performed or induced in violation of this section, may not be criminally prosecuted for violating any of the provisions of this section or for attempting to commit or conspiring to commit a violation of any of the provisions of this section, and is not subject to civil or criminal penalty based on the abortion being performed or induced in violation of any of the provisions of this section. If the pregnant woman testifies against another person who violates provisions of this section. This is a compromise of where we were prior to the false doctrine of Roe versus Wade. This is where our legislation before us was, so there's precedent in the law for that.
Are you finished, Senator from
Yes.
Greenwood? Okay. Senator from Greenville.
Mr. Chairman, I was torn on this along with some of my colleagues. And the fact remains that for 60 years, 2 generations since Roe v. Wade, we have taught our young ladies in this country and our women that abortion is okay. They were acclimated for 2 generations. And although in my obviously my Christian view that that was not right, but that was what society. And now, just in South Carolina, since we've had the opportunity, we've over the years done attempts at dismemberment bills. We've done the fetal heartbeat bill, had to do that one twice. We've been through a lot of hard work, and I have co-sponsored and fought for and worked for every pro-life legislation that has ever come before the Senate, engaged in them and waded into the battle because I believe in it, because I don't believe in abortion. But because of the history of this country we went through, I do believe that your 35 years is extreme on one end. To do nothing to them is probably extreme as the author did on the other end. This is a compromise here that I can be in favor of. So I plan to vote for the affirmative, in the affirmative.
Senator from Sumter.
Thank you, Mr. Chair. Because, again, I'm not a lawyer, Senator from, whose amendment is this?
It's mine.
Okay, can you put it in layman's terms what this will do and not do? I appreciate that.
A woman cannot be charged with a felony and she can't get 30 years in jail or 20 years for a manslaughter or anything like that. In the abortion situation, she could get up to 2 years and pay a fine of $1,000 or both if she is convicted after trial. However, there is some immunity for her in the event she testifies against the people that provided the abortion, in whatever form it is. Then she has immunity from prosecution for giving that testimony. And I can tell you in criminal cases over the years, the state will generally have one person in a conspiracy or in a group of people who will come in and testify in exchange for a more lenient sentence. And this is something that has been recognized in our law since the 70s, when this was the law prior to Roe versus Wade.
Okay, well, thank you for that clarification. So this, what it does is this puts this back in sort of pre-Roe. Okay, and so what it does though is currently we don't have, beyond the abortion provider and a certain other situations, there's no penalty on anyone, the woman who receives the abortion, but this would then put at least a penalty, just not as severe.
A minor penalty is consistent with prior law,
Okay.
but also she has full immunity if she just testifies. To
Okay.
Senator Cash's point, you might need somebody to testify. Who did you get the drugs from? Who sent you these drugs in order for us to prosecute the abortionist?
Okay, and so thank you for that. That leads me to my next question. I'm just trying to get clarity here. So is there a penalty that, so this, this was just introduced to me and I haven't had the chance to really absorb it, but so there's a penalty, but it's a monetary penalty. It's not a,
It is both
so
potentially.
you can,
It could
they're
be
up to
or.
2 years. They can be
Yes.
a prison.
That's right. Or $1,000 fine.
Okay, and
And
testifying, what does that do?
that is, if she testifies that she can neither be charged $1,000 nor the 2 years, nor the misdemeanor, as she has complete immunity.
Okay, so there is a way out to basically what I'm trying to see what the intention of this is. And correct me if I'm wrong, please fill in the gaps. But what this will do is allow essentially sort of to identify, put teeth and accountability into the current system and some oversight from if the woman gets an abortion and then works on behalf of prosecution of a criminal abortion, then they can. Do you see? I'm not a lawyer. Do you see where there? Suppose I don't want to what if this, because we've done this forever, but I will bring this one up. Suppose, for example, and again, I don't want to speak to this from the very fringe of the issue and the very minority of the abortion over the whole, but I do believe that much of what my colleagues have stated is we're in the business of providing clarity, And so I think that we need to take whatever extensive pain to do that, to provide the clarity into our law so we know what to expect, and our citizens know what's lawful and what is not. That said, will this allow, let me get this right. Will this bill, or I'm sorry, this amendment, is there a time where you would see that a young woman, suppose it was a 16-year-old girl who was, raped, or maybe even not, just engaged in a bad life decision and ended up, pregnant. And she supposedly, her mother, or for example, or a doctor or whomever, says, okay, there's an aiding and abetting element to this. They take him to North Carolina. Does that give the young 16-year-old the ability to essentially, and the responsibility or motivation to testify against their own mother or doctor? Would that be an outcome of this, possibly?
The situation is, regardless of who precipitated in helping her get the abortion, they would had aid in some fashion, financially or other, in other way. If it was an illegal abortion, okay, an unlawful abortion, then certainly they can be punished. And if they testify against whomever it was that brought about the abortion, then certainly they have immunity, or would have immunity under this bill. So no judge could hold them responsible, because the law says that they are not responsible.
So and thank you for that. So on this particular amendment and in this particular situation, just for clarity, would the 16-year-old young lady who had the abortion, if she agrees to help authorities prosecute, whomever it is, grandma, mom, doctor, whomever, yes, this amendment will give her immunity, but that's still the mother or whomever still is very vulnerable, correct, to that?
Yes, they would be
prosecution?
still
Okay.
vulnerable to the general penalties that whatever bill that ultimately comes out of the full Senate committee, and then whatever comes onto the floor, would be subject to whatever that ultimate penalty is.
Excellent. Okay. Well, not excellent, but certainly better, more clarity, and I do appreciate that,
Certainly.
sir. Thank you.
Mr. Chair.
I will get to you in just a second. Senator from Greenwood. Okay, you've opened a discussion here on the testimony, what I will call the testimony being given in exchange for prosecution.
In exchange for immunity.
Yeah, right.
Yes.
What, are you aware that that is in my bill in 44, 41, 615, capital F, point number 2? My bill says a person may be compelled to testify in any action or prosecution where the victim is an unborn child, provided, however, that such testimony shall not be admissible in any civil or criminal action against such witness, and such witness shall forever be exempt from any prosecution for the act concerning which the witness testifies, except a prosecution for perjury. Is that not, in essence, what your immunity clause says?
No, I think your provision is draconian in the sense that it puts up to 25 years, 30 years on the woman if the child lives or dies, and then also calls it a felony forever. So once they're tagged with a felony, the felony will be there forever, unless they come in and they testify, and then in that setting, the court can give her immunity based on the same document that we talked about a few moments ago. But the downside of yours is a felony and is one extreme, and my original one, which was no penalty, is a much lesser one. So this is
So are we disagreeing over whether you think you should have a felony for killing an unborn child, even though you can give testimony and be exempt from prosecution of such?
Yeah, I think that the situation and the precedent of our law has always been, prior to Roe versus Wade, was 2 years and $1,000. That's the way we looked at it back then. And so again, until such time as we have the unborn child from conception adopted and accepted into our law 110%, until that time happens, then this is the best we can do under the circumstances, in my estimation. You know, you've got several things here. You've got to get it through this committee. You've got to get it through a full committee, and then we've got to get it through the Senate floor. I'm all about saving babies. I'm all about taking it back to conception as close as I can, and a diagnosable pregnancy is where it's at. So if helping assuage some of the concerns that these women have, I'm all about it. I don't think punishing women is a way to achieve our goal. I think identifying the law, establishing the law fully, and then if later on we find that a lot of people are doing this, they're killing their children unlawfully, then of course the General Assembly at any point can increase a punishment if it feels in its wisdom that that's necessary. I'm just going back to where the precedent was back in 70 before we had the Roe versus Wade. That's where we were at then. And that's at a state where I think a lot of people were religiously a lot more inclined back then. And that's the decisions that they made, our predecessors in our General Assembly had made. So I think it's based upon good science and good substance, good precedent. But I agree with you. It's the same principle. Yours is just more severe than mine.
Well, I would say that my penalty is more severe than the penalty you are offering if you don't testify. But I would say my bill leaves the same option for the woman to be to give testimony and avoid prosecution. I think that's very clear, but I understand that my penalty, if she decides not to do that, can certainly be up to a greater amount. Senator from Charleston.
Thank you, Mr. Chair. Just on this, so the way I'm reading this, and I know Senator Zell asked a question, and so I want to follow up on that. So well, first let me get to this. So we're seeing that essentially this just creates a way out for the pregnant woman so long as they tell on who helped them get the abortion, right? That will give them immunity. And so, for example, it's almost similar to person A knows that the possession of drugs is illegal, but they possess drugs, and now we're telling them it's okay. But if you get caught, then as long as you tell us who supplied you the drugs, you're off the hook. Is that essentially not the same thing? I understand that, but when we go to criminal law, okay. Well, drugs affect life too. People can die, but okay. Well, I'll go one step further. So with the example that Senator Zell asked about, so we have a child or a young woman who tells their mother they want to have an abortion for whatever reason. Mom helps her to get to a doctor or either get the online pills to make that happen. They get caught, and now the only way for that child, who's the pregnant woman, that essentially, according to this bill, broke the law, the only way for that child to not get potentially 2 years in prison is to throw her mom under the bus and now allow her mother to get 2 years in prison for breaking the law. That's essentially what would happen. That is a real life example of what could happen, correct? Oh, mom gets 30. Oh. Yeah, so that's even worse. So we're pitting a child against their parent, essentially. How is that better than what, I mean, I get what you're trying to do, but now you're putting people,
Suppose the child, we still have to suppose she only tells about the abortion. She's talking about anybody except for the abortion.
so we're encouraging, it's saying, go break the law, but as long as you tell on the person that helped you break the law, although you knowingly broke the law, I mean, we may as well apply that to every other criminal code.
As well as I do.
I'm just saying, how is that fair?
You know as well as I do that, and if you're trying to use the drug analogy, that every day in courts around this state, a solicitor will offer one person who is involved in a conspiracy or an accessory or whatever, will offer one of those people immunity or a lesser penalty in exchange for testimony. It happens every day. You know that. You're a practicing criminal lawyer. So to say that that doesn't happen or that that's something unique or special, in our law is not being.
Well, that does happen, but it does not grant automatic, just outright immunity. It may make the charge lesser. There may be some other things, but it doesn't give absolute immunity to breaking the law. And I get what you're trying to do, but when I look at the example with the child who wants this to happen, mom helps them, and now for some reason they get caught, and now the child is put in a position to tell on her mother that mom ordered these pills for me online, and now the mother faces prison. Who's going to take? I mean, now the mom's in prison, and even to your point where she can say, well, she can not tell on mom and then tell on the provider. But what if mom is the one who bought the pills from the online?
I don't think honestly that a court's going to put them in jail.
I look at that a lot, and the way these,
again, I don't.
You and I practice law. We know that you never know what's
chances-
going to happen, county by county.
Well, that's true, but for the most part, no prior record, clean bill of health, those kinds of things that judges look at and making decisions. I mean, even if they don't testify, they're looking at 2 years.
That's a lot. I mean, for
But
just prison,
that's the
any time in prison
That's
is
the maximum's 2 years.
But they could get
just
2
be-
years.
It could be $1,000 fine.
It could be, but I've seen judges do some odd things
Well,
sometimes.
judges have to have discretion. We
Right.
have to give discretion in those cases where the circumstances are such. And I'm fine with leaving, instead of having mandatory minimum. I hate to tell you this, but if you go back and look at the earlier statute for doctors, the mandatory minimum was 5 years. Go back and look at it. I've got a copy of it. You want to see it?
Well,
It was 5 years for the doc, the mandatory minimum.
I hear what you're saying. We'd have to put our faith in that the judge would not sentence a mother up to 2 years in prison for essentially doing what she thought was right based on her conscious decision and what she and her daughter believe. And I struggle with that because the pressure, the pressure on this issue to the judiciary.
Senator, you didn't vote for my amendment that wasn't going to punish her at all. I tried to.
Well, we didn't include the doctors.
Listen, if you want to put up an amendment about the doctor, sir, go for it. I get that.
You're gonna vote for it.
I understand that.
Okay.
I'm dealing with the moms right now.
Well, I just think it's bad to pit a child against a mom for this.
I'm not happy about anybody killing their baby, period.
Just a second. I'm going to make one comment and pass it over to you. You said, I don't, well, I don't know about that.
I promise you. Just really, Mr. Chairman, wanted
Go
to
ahead.
correct the scrivener's error.
Oh, I see that.
Yes, you see it?
That's
Yeah,
what
not
it
be
is.
2 times.
Yeah.
Yeah, just need to strike that.
Thank you.
Told you I was gonna be short.
Only
I didn't read it.
comment on that conversation, Senator from Charleston, and I mean no disrespect, is you're talking about pitting a mother against her child because she gave her an abortion pill. That's exactly what abortion is. It's pitting a mother against her child. It's wrong. And that's what, as a culture, we've done for 50 years. Pit mothers against their children and tell them the best solution sometimes is just to kill the unborn child. That's why we're here. So I do agree it's a difficult situation that you have articulated, but it's all difficult, is it not? Are there other comments on this
Mr. Chairman.
particular amendment? Senator from Orangeburg.
So I just want to address one thing that the senator from Sumter asked. This notion that subsection 3 is going to grant you immunity if you testify is not going to apply in, by your statistics, 84% of the cases where the woman themselves procures the pill and takes it without anybody aiding and abetting potentially. I mean, they may have driven to New York and got the pill lawfully and brought it back to South Carolina and administered it to himself. There's nobody to testify against. Nobody has committed, according to this, any crime but the woman who ingested the pill. Prescribed a prescription in another state where it was lawful because it wasn't unlawful here. So there is nobody to, quote, turn in and get your sentence reduced. If you're one of those 84% of the women that you just said was the statistic these, I think you said 84% these days, Section 3 will never apply.
Anyone else? Okay. Hearing no further discussion, we will go to a vote. This vote is to pass this amendment that we've had under discussion. All those in favor of this amendment, please raise your right hand. Okay. All those opposed, raise your right hand. Okay. The vote is 4-4. The motion fails. Are there any further amendments?
Yes, sir. Mr. Chairman, I've got some amendments.
Okay, Senator from Greenville.
Pull out the stack.
Okay. Mr. Chairman, we will, we'll start with this one. Somebody wants to pass it out.
Okay, Senator from Greenville, if you would explain.
Simply delete section 4441.615C, which is under some of the aiding and abetting. And C says it is unlawful to knowingly or intentionally aid, abet, or conspire with another person to violate provisions contained in this section. The provision against aiding and abetting include but not limited to knowingly, intentionally providing information to a pregnant woman or someone seeking information on behalf of a pregnant woman by telephone, internet, or any other mode of communication about regarding self-administered. Knowing the information will be used to likely cause an abortion. Hosting or maintaining an internet website, providing the information, and we used in offering, make sure I didn't go too far, section C. Yeah, offering the, a referral to an abortion provider. And it goes on talking about, the referrals, the use of force or threat, recruit and harbor, transport. Basically, this one, I scratched my head, and I understand, I believe, Mr. Chairman, what you were wanting to do. But I specifically spent some time with our lead staff attorney about this code section. And I was led to believe that it was unconstitutional. That you can't regulate free speech, although I would never, it would break my heart for somebody to tell somebody where to go get an abortion. As I stated earlier, I have co-sponsored and fought for every pro-life bill that has ever come before me. But I took an oath to uphold the Constitution of this country and this state. And I'd have a hard time supporting a bill with a section in it that can and can't talk to somebody about. Finished? Yeah, for the most part, yeah.
Okay. All right, so the amendment is to strike this section on aiding and abetting. I think one way to think about this, Senator, and I understand your desire to stay within constitutional bounds, is that there is towards the end of the bill that is a free speech section. It says 44, 41, 700. This article may not be construed to impose liability or conduct protected by the First Amendment to the United States Constitution or by the South Carolina Constitution. That's section 44, 41, 700. Now, getting back to the specific clauses here on aiding and abetting, I would encourage everyone to think about this in terms of what can you lawfully do if you were trying to hire someone to kill someone else, which people try to do that, by the way. You know, if someone comes to you and says, hey, I mean, I'm sure you've read about cases like this in the newspaper and on the news. I would say put a situation like that in your mind. Can someone host an internet website about how to get an illegal hit done and say, well, you can't stop me from putting up information about where to hire a hitman and where to get the drugs for the express purpose of killing someone. You can't do that. That's free speech. I think free speech always has a bound. You can't yell fire in the theater, so to speak. And so I know that we're talking about the internet. But you know, people get in trouble and go to jail right now because of stuff that happens over the internet, whether it be child pornography or any number of things that don't get found to be free speech or conduct. So he reviewed this. I mean, I had help drafting this bill, including on that section. I did make one change to this bill earlier. Woman might need to refer her to someone who's a specialist in the case of emergency. And so I inserted the word, you can't have a referral for an unlawful abortion, an abortion that would be outside of that medical paragraph that we vetted with the heartbeat bill. So, those are my comments. I realize that each and every part of the bill will be scrutinized. There's not a pro-life bill we've ever passed that wasn't sued, the day after it was signed, so to speak. But I do think that we have to have a mindset that you don't have a right to provide information to someone on how to kill an innocent person. And I mean concrete information that someone is likely to act upon. You simply don't have that right. And the unborn child is, in my belief, is deserving of that protection from people who would be seeking to aid and abet its death, as anyone in this room is deserving of a protection from any conspiracy to kill one of us. So that's just kind of the way I see it. I realize at some point the courts would review.
Well, that's what I fear. That's what I fear, Mr. Chairman. As hard as we've worked to save the unborn, and we have to put sort of odd things in this bill that do bump up against the Constitution. Why go there? Why can't we just focus on our mission, what has been the mission of us pro-life people in the Senate all these years, and keep pushing forward in that direction and risk, because the attorney said that this attempt to criminalize even discussing or sharing of information concerning abortion, this is a First Amendment violation that would threaten the bill and possibly get it thrown out and challenged and thrown out. And about traveling with minors across state lines for the purposes of having abortion, freely traveling between the states has been recognized as a fundamental right by the U.S. Supreme Court. I believe this section's restrictions violate that fundamental right. Furthermore, the person transporting the minor.
Senator, I've already changed that section. I've already amended that. With that's referring now to trafficking. It's without parental consent.
You fixed that.
Yeah, that was
part.
in the
Okay.
catch-all amendment.
I thought you touched on it, but I thought this gave it
No,
more clarity.
Yeah,
Okay.
no, and that's why,
Right.
because I don't think you can stop someone from traveling to another state.
Okay.
So,
Because I'm trying to fix this bill.
well,
so
I
it can
understand,
move
and
forward.
I agree with you on that. I mean, as
Um,
I studied it, I realized that needed to have a few extra words in there.
And I just have a hard time voting on something that I swore an oath to uphold this Constitution.
I understand. I will say this, there's a severability clause at the end of the bill, that if one part is found unconstitutional, that does not strike down the whole bill. I will say this. There's two keys in my bill, I believe, to actually protect the unborn child. One key is no one, including the mother, can have legal immunity or impunity to kill an unborn child without legal consequences. Like that, we have gutted the bill. The second thing is no one can participate because the pill trade is a real thing. And if either one of those, because if there's no accountability for a woman, and if aiding and abetting is not really an offense in here, well, then what you've done is you've established a law that does nothing to stop what is right now probably 90% of the abortions, which are done at home using pills. Because if you take out aiding and abetting, then everyone can provide information to the woman about how to get the abortion. I mean, it just goes on. And then the woman takes the pill And as the senator from Orangeburg was arguing, there's no one to point the finger at if she's got immunity. And so if there's no prohibition against aiding and abetting, then we're basically saying that when it comes to the unborn child, they don't have the protection that you have from people who might conspire to kill you because they don't like you for whatever reason it is they don't like you. And that's all I'm trying to accomplish. If the court finds a part of it that they consider unconstitutional, then I understand they could rule on that. But I do think the severability clause is there in the bill. So I appreciate the desire to try to make sure we're staying within constitutional bounds. And I realize perhaps that I'm pushing right up against it. But I am trying to give all want should someone conspire to kill us. Are there any other comments on this? Anyone else want to speak to this? Senator for Sumter.
Thank you so much, Mr. Chair. Again, I'm going to say this preface every time. I'm not a lawyer, but I sit around a lot of them that know what they're talking about. That said, I didn't really put much emphasis or thought into the freedom of speech aspect of this particular bill, and so it's a very good point. And so I feel like I'm just coming, walking in the room on that part of the conversation. Which, sort of unfortunately puts me in a position where I'm not confident in this amendment or the current statute as it stands. And so that said, I think that's a very interesting element. It's very gray, obviously. Freedom of speech issues always are. But that brings up this question. Suppose, because I'm a layman here, and so I need things drawn out with crayons, and I need picture books to point at. Suppose the conversation in the Supreme Court does take up this, and obviously we know what the left is going to do on this immediately. This thing, if it gets passed, it's going to be challenged. That is no question. That is baked in the cake. But it does bring up good questions about the how far you can actually go with this. And so my question is based in that. I wish I would have asked this during the testimony in the hearings, because one of the questions I would have been asked based on this new information is, what do our medical institutions teach and instruct? Do they teach all the methods and processes of abortion? Do they not? Is it, are states different? And so that question leads to this. Where does aiding and abetting start and stop? And so is it, I understand, our medical providers would, in the case of, exception or emergencies, health of the mother, things like that, they must be prepared to handle that sort of emergency. But when a clinician is using their scientific clinical best judgment, barring political affiliation or religious perspective or whatever it is, just in that moment of chaos, they're looking at the health of that mother and that child. At what point they were going to become a doctor to involve themselves in this profession, up to the moment that they're trying to save the life of that mother and hopefully that baby. Where does it start and stop? And that's really the question. I think it really, I'm a little concerned about making a judgment on this amendment one way or the other, just because I'm not confident in my knowledge of it. So I'm not sure what we can do there with that. I in good faith, Mr. Chairman, I truly want this bill to pass out of this subcommittee, because I think that we can get it will be a vehicle to help save as many babies as we can, regardless of how it ultimately ends up looking. But I fear that personally, and I'm not speaking for anybody else, that I'm asked to consider amendments and information that I'm not fully comfortable even opining on. So I guess what I'm saying is, how can you make that less palatable for me as a representative of 110,000 people in my 4 counties, and then on this subcommittee, more largely and broadly, the sort of the will of the people of South Carolina?
Well,
So that's a big question. I don't really know how to answer it.
well, yeah, but it's a great question. And the way I read the bill and understand the bill, let's just do a quick scenario. Your next door neighbor walks over to you and says, Senator, or he probably calls you Jeff. Jeff, my daughter's pregnant, and we don't know what to do. She doesn't want the child. We're just all tore up about this, whatever the conversation leads to. And you look at that neighbor and you say, well, we've outlawed abortion in South Carolina. I mean, you'll have to go to Asheville to get an abortion now. If they go to Asheville and get an abortion, well, you've aided and abetted. You have told them where to go to get an abortion. So, it boils down to just basic free speech. I would tell them to pound sand, look it up yourself. But there could be a case where walking a line that I'm not comfortable with.
Thank you for that. And so I guess for clarity, so this amendment should clean that up, or at least give this portion some clarity as far as like what's acceptable, what's not. And then, Mr. Chair, I guess this question's for you. You're saying that the severability clause did position of the average lawyer, I guess, or I mean, would that be something that would be considerable if we pass this through? And I'm not definitely like, I'm with you on the constitutionality. We need to stay within those confines as absolutely as much as we can. That's why we have the third branch of government and the judiciary to make sure that we do. So I'm just a little uncomfortable on with this particular provision. So, but I'm willing to follow your lead on this. This doesn't seem to be a showstopper for me. If the severability clause is sufficient, then the courts should have their day.
And I only offer it because I want the bill to go forward. I think the bill has a lot of issues that need to be fixed, and I was hoping we could get them fixed here, but it's been a challenge.
Thank you, Mr. Chair.
Yeah, I'll say a few things. One, I think the pound sand is the proper answer when a neighbor asks you about killing an unborn child or a born child. My child's just become so unruly. We can't take it anymore. You're not going to say, well, we've outlawed killing children here, but you can go up to North Carolina and do it. I mean, your reaction would be, no, you shouldn't even think about killing your child. That's a gift from God. Again, I think the only way to process some of this stuff is just to bring the born child into the conversation and say, can you say that and can you do that when you're talking about a born child? Now, the law may say different. I guess, I don't know if this would give you any comfort, Senator from Greenfield, but, I added a word in number D for clarity. I added a phrase in D2 for clarity. If you came back and I would just suggest at full committee and say, here's a few words we could put here or there that might make these provisions more constitutionally impregnable, I'd certainly consider that. But just to strike the whole section on aiding and abetting, I'm not willing to do that because the unborn child has had no legal protection at all under Roe v. Wade. And we have a duty to give that child protection. And I know these subjects are difficult to think about because we haven't had to think through the intricacies and the details. I'd be more inclined to want to take that in a more detailed manner than just would do a lot towards.
Well, Mr. Chairman, how with the section on providing internet access and websites to tell people stuff, how are we going to enforce that?
How would they enforce it now would be my response. I mean, what would SLED do now if you put up a website and said, here's how you can hire a hitman to get rid of your neighbor that you don't like? You've always been wanting to do that. I mean, just put it in those terms. What would SLED do and what should they do? If you're offering information on how to kill an innocent person who's protected by law.
It's my understanding that they're almost impossible to track down these through the web domains. They go through.
But does that mean it shouldn't be in the law? Should we not try to stop child pornography? We've even got to pass a law now where we're trying to stop what do you call it? Morphed images, images that are AI created. We're trying to stop that in the code. And that's not even a real picture per se.
Not even a real person.
But we think it's criminal activity that is detrimental to society. Surely if we can try to stop that on the internet, we can try to stop getting information on how to kill an innocent person if the innocent child is protected by the law. And I think we just have to think about it in terms of if the unborn child is viewed with the same right as the born child, then what can someone say? What can someone post about how to kill a born child and still be within the constitutional rights of free speech? That's the best answer I can come up with, Senator. I think
Very complicated, yeah.
That's complicated too, but we this past year, and I think it was right that we did so. So again, I'm willing on the level of changing words. I want to recognize anyone else who wants to be heard. Senator from Charleston.
One of my concerns is that we may not be being consistent. I know that in the recent past, we've also outlawed the sort of trans surgeries, mutilation of children. But did we make it illegal for the doctor to tell that set of parents they can go to Asheville to have that surgery? I don't know that we did. And we might not have done it because it is, as Senator Greenville brings up, it's so difficult a matter to consider the free speech elements of this. And Roe, when that changed, it is bringing all these questions in the light. Difficulty I had with the previous amendment about 30 years for a mother. I don't want to put any we're going to have the audacity to write a law. We can't do carve outs. We can't say this class of citizen gets no punishment and this one gets the max. I understand that there's different ways of looking at, maybe a drug trafficker gets a lot of time and the guy on the corner selling a dime bag doesn't get as much. And I thought that the previous amendment sort of was trying to hit that spot in that sort of way of thinking. But if we weren't going to make it a criminal act for a doctor to discuss going to Asheville for the trans surgery, we're just not being consistent. It's difficult for me to put my head around that, considering these laws. Yes.
I guess my consistency here, Senator for Charleston, is trying to treat the unborn child the way I would treat a born child in protecting his life when someone is conspiring to kill him or her. I'm not saying that it's easy. I'm saying that laws establish what we can consider to be standards of justice that are good for society. Doesn't mean that they're always easy to enforce, whether it's morphed images of pornography or whatever. But I can't go to saying, therefore, we shouldn't have a law. But you know, that's where my consistency lies in trying to protect the unborn as we would protect the born child.
I know you respect the idea of the freedom of speech element involved here and being able to discuss certain matters. So that makes it even increasingly difficult. Maybe this is an amendment that we can think more about and maybe carry over to full committee. Instead of taking a vote today, I would be more comfortable voting on this in full committee if the author would consider that.
Well, I would prefer to get a vote now because as much as these actions I would like to see go through, I'm with Chairman Cash for saving babies, but I swore an oath to uphold the Constitution. And I'd like to deal with this now.
Is there anyone else who wants to be heard?
Mr. Chairman.
Senator from Orangeburg.
You learn something at every meeting you go to, but I did not know that go to Asheville was the go that you didn't know about. So address the Senator from Sumter's question about whether it was going to cost us anything, and of 8 of the financial impact, in which our flagship medical university says it's going to cost about $500,000 a year to train our residents out of state. In other words, when you take OBGYN and you get accepted into the residency program, they have to be trained across the entire spectrum of OBGYN, no matter what facet they plan to go into in their practice. They've got to be trained in everything. And we're not going to be allowed to train our doctors in Charleston. So we're going to have to pay their tuition to go to Asheville and get trained to the tune of $410,000 a year. And that's if you can recruit doctors who want to come to South Carolina and be trained at what will now be probably deemed to be a subpar program, because we can't offer all facets of the training.
Senator from Orangeburg, I don't know.
You go put a proviso up to strike money from MUSC going to this.
Yeah, I don't know quite how to respond to that. I certainly don't recall any testimony at subcommittee about doctors would have to go to North Carolina. The bill does allow for doctors to provide emergency care for women in those situations. So I in that regard, I don't see why the MUSC could not provide the training on how to save women and babies whose lives are being threatened by a pregnancy. I just don't see how they can just say, well, we can't do that anymore when the bill is very clear that here are all provision. So, I didn't hear any testimony about that. I just cannot. That's not going to affect my view of the matter. But thank you.
You flipped it on its head, though. It's not that they can train them on intervention. It's that they train them on how to, say, perform a DNC. It's how they train them to actually perform abortive services, because that's part of the range of the standard of care within the medical profession, is that you have to train on all that, whether you'll ever use that or not in your training. You have to know about it.
So when a woman is having a miscarriage and the baby has died and they perform a DNC, in which case, why couldn't they be trained on how to do a DNC?
Let me just say this. I didn't write this, okay? Somebody from MUSC put this in here. I didn't put this in here, and they did testify to that. They're going to, it clearly says fee to train residents out of state. We have to pay to train our residents out of state.
Any other comments? Okay, hearing none, we will go to a vote. This is a vote to strike the section on aiding and abetting. All those in favor of passing the amendment, please raise your right hand. Okay, all those opposed to passing this amendment, please raise your right hand. Okay. Amendment fails 5-4.
I've got one more real quick. It needs a little cleanup because it says it's a defense for her, which is the language that's already in the code. I'm not sure what the sentence says that she probably have to hire an attorney. You know, we could have to hire an attorney. My next amendment just says that in case of the life of the mother, it is not applicable. I'll show you the amendment. What's in blue is the amendment. I can hold it for full. Okay, let's go to Senator Zell's amendment.
Mr. Chair, I'm, just a moment of a point of privilege, if you don't mind. Where are we at on this? Are we waiting on anybody else's amendments, or are we going to?
I'm not aware
Okay.
of any amendment unless you have an amendment.
I do have an amendment I would like to discuss.
Okay.
Okay, so, well, thank you, Mr. Chair, if you're ready for that.
Well, we need to get it distributed.
Sure.
Thank
I
you.
have- Grant, are these sufficient? You know? This is the one I got the clerk's office printed them out for me. So if you don't mind. Thank you. There will be one change to this, as discussed, I think to make it more palatable. But first, if I have just a moment, I'd like to sort of talk about where I'm at on this amendment before, to give you some context. So, you know, and not to talk about the bill specifically overall, we'll get to that as far as, you know, voting on the overall bill. But I just sort of want to put, you know, on record where I'm at and why I'm here. You know, I think we all are aware that currently as this bill is written, it's very challenging for a lot of folks to get behind certain provisions of it. I'm certainly one of them. And it's not necessarily my own personal perspective on this. It's the will of what I believe to be the largest, you know, the large majority of folks that have reached out to me and on both sides of this issue. But I think there's a demographic of folks that aren't really being talked about or considered, and that is the vast majority of the quiet middle on this issue. And so what I hope to do is, you know, like I stated earlier, is in very good faith. There's a reason why I kept quiet about this issue in public, because I deeply respect you, Mr. Chair, and what you're trying to do with this and saving lives of babies and everything else and moving this ball forward, which I absolutely support that effort. But I think you know, much of what was stated today amongst, you know, this body, there are big concerns, and I'm sure, you know, big hurdles that we have to get over to make sure, you know, if we can get this into full committee, we should. Because I think that on all sides, we want the same thing. I think if that is to help save as many lives as we can, and to do that. So, but I also I'm not going to be bullied by a vocal minority either. So I'm no champion of the left, and I never will be. And any claims to that, you're wrong. I'm going to prove you wrong. I'm going to disappoint you. I promise. Because I know where I'm at, and I'm not, I'm willing to hear out, suspend my bias. But so that said, I am offering an amendment to restore exceptions of rape and incest into the bill. And so of the four big exceptions that we usually talk about under, regarding abortion is rape, incest, fatal fetal anomaly, and health of the mother. And as I'm aware, your bill actually does protect the health of the mother. Correct me if I'm wrong, is that correct? It's the one exception it does
That's
carry.
correct.
Okay, thank you for that. But there's a lot of consternation as I hear it from the body of our constituency across the state, certainly in the 36th Senate district, that is telling me, hold on. Y'all spent an inordinate amount of political capital and energy and effort and in good faith, I believe, to get the 6-week abortion heartbeat bill passed. But I think because of the timeliness of this particular bill, following subsequently the passage, the hard fought fight that you all should absolutely get an immense amount of credit for, I think that this is, I'm not sure if the timing is right. And oftentimes what I hear are folks saying, let's, and I obviously hear the criticisms of this as well, but it's let's see what the current bill does. Let's see, and I know you addressed it to some degree, and that gives us, obviously, we have some initial preliminary data to tell us sort of is it working, is it not working? But I don't think that we've had enough time in between implementation of the bill and now. I don't believe personally that it tells us the whole story if this law currently does what it was intended to do. I don't think we have. I think the jury's still out on that. And so I'm offering this. I was going to offer the three exceptions back into the bill, but under consideration and conversation with other senators and what they're comfortable with, and in good faith to try to move this out of subcommittee into committee so we can get a much more robust hearing and broad perspective. I'm going to forego adding fetal fatal anomaly. I think that's something I'm definitely interested in, and I will certainly bring it up if we can get this thing out of subcommittee and into the full committee. I'm certainly not punting it or kicking the can down the road. I just want to make sure that we can, in good faith, get this bill forward. So that was the intent of this amendment. So essentially, it's as straightforward. What it does is it moves it right back to where the current law is on those two exceptions, and that is rape and incest, and also preserves your exception in your bill, and that is health of the mother. And so that's essentially it. It's really cut and dry. It's just basically take what is current law and just puts it. And I want to say this, Mr. Chairman, is this certainly is. I hope that this amendment doesn't strike you as an offense, because this is not the intent of it. I truly want to help you move this pro-life football down the field and to save as many babies as we can. But several of the positions in the bill as it's just something that I can't support as is, and that is what I believe the will of the South Carolinians. So that said, if there's any questions on this, I can certainly talk about it a little more. It doesn't change current law. It's what is in here. Adding fatal fetal anomaly would change, and so that's just something that we can have later on down the road. But rape and incest is the exceptions I make me far more comfortable. So.
Well, I can do that. Okay. Okay. So, or he can do it. So, may I have the floor, Mr. Chairman?
Senator from Greenville.
So, Senator Zell, is it my understanding that all reference,
Yes,
and the only thing left in this would be the rape and incest?
that is correct.
Okay,
With
because,
the intention that we will revisit it at some point.
right,
Yes, sir.
and I appreciate that because, I've worked for 2 weeks very hard, and I've contacted my colleagues here by phone multiple times, trying to figure out what issues you have with the bill, what needs to be amended to get your vote, how, the next colleague, I heard a repeating theme, of this has got to be fixed before I can vote for it. Obviously that did not get fixed, but I even spoke with the chairman, Senator Cash, who's a good friend of mine, back in February, and he told me that he figured the exceptions would probably get put back in because I've been pushing pro-life bills for 14 years, and I know every pawn, I know every pawn on the chessboard, and I know what the others think in the full Senate, and I've never seen one leave without the exceptions in it, regardless of how I feel about it. It's just if you want to move the ball forward, that's the way they come out. Okay. And that's the reason
I'm sorry, can you repeat that last sentence? Make that make sense?
I said every bill that we've ever dealt with in the Senate has the exceptions in it.
Sure, okay.
Rape, incest, life of the mother, regardless of how I feel about that, they get put in. Okay. So, and regardless, and that's why I told you when I was on the phone with you several times in the past few weeks that regardless of how I feel about it, I'll support you in this amendment without the fetal anomaly
Yes,
stuff.
sir. And
Because-
I've heard you loud and clear, and Mr. Senator, you were not the only one to bring this up. I think it's a point of conversation that we must have. But as I stated, in good faith, to try to get this thing out of subcommittee, this is one of the ones that I just can't overcome. I can't support this bill if the two provisions remain, and that is criminalization and in any format at this point, and the complete removal of all the exceptions. So unfortunately, I think I just flashed my cards a little bit, but I'll tell you, that was coming into this.
Since you did that, do we have to deal with this amendment?
We don't, but if it doesn't, and this is sort of my line of demarcation and line in the sand is, I can't support the bill overall. So, and that's just where I'm at. I believe that's what the will of my constituency is. And unfortunately that's a sort of a non-negotiable for me.
That's why you were elected to be a representative
sir,
of those people.
The hard
And
stuff. That's right.
like I said, I don't really relish going with you on a yes vote on this, but if it'll help get your vote, I will.
All right, Senator Zell, it's my understanding that you want to remove definition 5, fatal fetal
Yes, sir.
anomaly.
Any inference or reference to
And you
fatal
want
fetal
to-
anomaly. Yes, sir.
Remove section H on the second page. Remove section H on the second page of this amendment.
Yes, sir. That's correct.
Would you put that in the form of unanimous consent, please?
Sure. Let me, Mr. Chair, unanimous, or to remove the fatal anomaly provisions in and, maintain the rest of the language to reinsert incest and rape into the bill.
Okay, unanimous consent requests. Are there any objections?
I'm looking at section C on page 3. Does this bill or your amendment change the penalty provisions of the ultimate bill?
I'm
You're saying
sorry.
here, guilty of a felony and must be fined $10,000, imprisonment for not more than 2 years or both.
Sorry, sir. I didn't hear you, unfortunately. Please repeat that.
What I'm saying is to go to page 3
Mhm.
under subsection C. It provides there, though, that a person who violates this section is guilty of a felony, and upon conviction must be fined $10,000, imprisonment for not more than 2 years, or both. Are you attempting to change the penalty provisions of 323 by this amendment?
No, as I am aware that this bill or this amendment only strike or only reinserts what's in current law. Maybe there's somebody, Mr. Hogan or somebody that could speak on this. Is that current law?
I've just seen this, Senator, so I'm
Okay, all right.
struggling to catch up.
Sure, no problem, no problem.
It was my understanding that that was pulled from the heartbeat bill, if I'm not mistaken.
No, my intent.
So effectively, that would be contrary to 323.
Yeah, that's the point.
The penalty provisions of 323.
When it talks about person who violates this section, is it only referring to 650, which he is adding back in? I mean, 650 is a section, so he's saying this, he's saying for rape. So that doesn't carry over to the other sections. That's what it says.
Mr. Chair, if I could speak on this real quick. Well, some clarity was just offered, and I do apologize for not clarifying that. If this is, what I'm trying to do is not create any or no more than 2 years felony violation for doctors that that it is, then I am maintaining that. I'm not sure if that's what this says, but that was the intent of. Okay, yes, it was just to simply maintain current law, not to change it in one form or another. Does that, what you read, does that say?
That's the way I understand it,
Okay.
that penalty would only apply to this. I understand it.
Yes, Mr. Chairman, that is the intent, and if that's what is understood as written, then yes, I will maintain that.
Senator
But,
Charleston.
Mr. Chairman, in your bill, you're not suggesting that the penalty only be 2 years.
The penalty for what he wants to insert would only apply to this section that he.
But we're giving exemptions. This is in the discussion of exemptions. So there's no violation on exemptions. This would be for the entire bill.
This is creating an exception for
Upon conviction of what?
someone who
Illegally aids in abortion, a
So
doctor.
now we want to do 2 years.
They're already, as I'm been made aware that is the current
Yeah,
law.
but we're not restating current law. We have a new bill here
Sure.
that we're considering.
Well, that's what this
that has
amendment does.
different terms.
Sure. Well, that's what this amendment does, is reinserts current law.
Okay, all right, I have a suggestion from Mr. Hogan. If what you are trying to accomplish is to put back in exceptions for rape and incest, Mr. Hogan suggests committee. That is the suggestion. I'm not into it.
Whether it's adopted in this subcommittee or not, it will absolutely be offered up in full committee. Willing to carry this over, if that's what the correct terminology is.
Okay.
But yes, sir.
Okay. All right. Are there other amendments? All right. So if that concludes the offering of amendments, then basically we are on the bill, and any further discussion or debate that anyone wants to offer on the bill itself at this time. Senator?
Wanted to stay, but there was a handout I wanted to bring up, sort of about to talk about the bill. Gentlemen, look at there's a handout that it's a South, and bear with me. You may not see germaneness here, but I'll make it make sense. Coefficient Polling put out about 2 months ago, a poll on the gubernatorial race, and it polled about 1,200 or so registered Republican primary voters. And so why that matters is if there is one particular voter class that stated this was a statewide poll, and this isn't. I'm not even going to talk about the popularity of the candidates, because that's not the point at all. But what it did was it asked in the very end, if you go to the very last page, it says most important issue. They asked the question of of all the primary Republican voters, what was their most important issue that they're facing by ranking a ranking system. And so what this tells us, if you look at it, it tells us that of 11 issues, with other being one of them, that the pro-life issue, and this isn't to degrade the importance of it, but the pro-life issue, after taxes and spending, inflation, government corruption, law enforcement and crime, infrastructure, border and immigration, saving democracy, whatever that means, pro-life, Second Amendment rights, energy independence, and other. So pro-life, to the point I was trying to make, if we are looking, in majority is, I think this poll buttresses the point that there is considerable fatigue on this issue. It's pro-life falls under saved democracy and above other, and it polls at 4%. And of course, I know what one side of the aisle is going to say in 3 years when it comes election time, that Jeff Zell is a liberal that does this, that, and the other. Fine, say what you want, play your politics. But I'm not interested in that. What I'm interested is in speaking on behalf of the South Carolinian, and they're not interested in this bill right now, or this issue right now. It says this, not in any majority way. So my perspective always was, I'm going to do whatever I can to inch that ball down the field to save as many lives as we can, as we all are, I believe. Where we should go, and what the will of the will of South Carolina is, and the idea that South Carolina has its own right to its own determination. And so if we are to talk about this bill at 4%, then I'm going to try to use it to whatever advantage we can to do. But under the two conditions of criminalization and exceptions, with the good faith of that, as long as, kept it quiet in public, had very meaningful conversations with you all on this to figure out how we can actually move this forward. But what I couldn't do is support the bill under those conditions. And as of the criminalization still exists. And so on that, as much as I would love to, I can't vote in favor of this bill. And I was hoping that personally we could. Now, that is no impugnation of anybody here. I believe you strongly believe in your values and your positions, from the far left to the far right and everybody in between. I just don't want to forget the people that most matter, and that is the South Carolinian. And so I'm trying to listen to their voice, and what that tells me is that I can't support this bill as is. So that's all I wanted to say, Mr. Chairman. I deeply appreciate what you do here. I absolutely stand beside this ball forward. The fact of what we're asking what we're asking South Carolina to do right now is something that they're very uncomfortable with doing. So I appreciate it, and thank you for your time.
Thank you, Mr. Zell. Other comments? I will make a order from Sumter, not trying to be too pointed towards you, but an interesting point or two that I would like to engage with. And that is, to what degree does it reflect polling, right? And what importance do we place on issues when there's a smorgasbord of issues to look at? I think the other interesting point you've raised is how do you make decisions on issues that come before you as elected representatives? Do you just do what, et cetera? How do you make those decisions? I think those are both valid and try to answer for yourself as an elected official. And so my take on it is this: I believe most of the issues that we deal with down here in Columbia are primarily political in nature. And most of the bills, we decide where we stand based on our political principles, whatever they may be. Limited government, that's a political principle, less taxes, whatever. And so as representatives, I've always made it clear to people in my district that when it comes to political issues, I'm a conservative, and you can expect are decided on political principles. There's a smaller number of issues that are just very much more constitutional in nature. Amendment. When a bill comes up and it involves gun rights, and the Constitution becomes arrive at our opinion on the legislation. And then the smallest number of issues that we deal with, but certainly the most controversial in nature, are issues that I think fall clearly in the realm of morality. And it's certainly been my experience that there is no issue that we have dealt with in Columbia since I've been here that more squarely fits that classification of issues than an issue of the taking of the child's life in the womb. And so my position, and I've remarked to this to many people on many occasions, is on moral issues, I'm not taking polls. I'm trying to discern what kind of biblical wisdom I can get, the Christian, and the more clear the issue is, in my judgment, based on what the Bible says, the stronger my stand's going to be. Okay. If the issue is less clear, then my stand won't be as strong. In this case, the issue to me is pretty clear cut. And that gets back when life begins, fertilization, etc. What value do you place on that life? And so I don't know that this is a different way of operating than you're articulating, but if my entire district says no, then should be available. Probably not going to vote for me at the next election because I'm never going to agree with them. I'm going to say, well, that clearly contradicts what I perceive to be the very clear direction of God's word. I can't change on that. As far as, 4% of the people say this is important to them compared to other things, I'm not going to disagree with that. When you throw up a smorgasbord of issues, just without any real, I'll just say context, people are going to choose, what and I think it becomes very individual in nature for us as elected officials as to how we decide what's our priority, what's important to us. And the answer to that is going to be just probably as different and varied as each elected official. I can simply say this, I think in all honesty, whenever I'm asked the question, and I get asked the question probably at least once a year in front of the Chamber of Commerce, what's the most important issue? I stand up before the killing of unborn children and bringing it into that is the most important issue in this state. And it's not that I don't care about economic issues, and I refute the idea that I'm some kind of one issue of all kinds of things like vaccines, regardless of our level of interest. It appears to me, if I seem to be very passionate and very focused on this, explain how I got here to that point. But I've never hidden it. The killing of unborn children is a moral issue. It will that allows the shedding of innocent blood over time. I think the Bible clearly teaches that. And I believe it's our first duty as elected officials to bring an end to it, to protect innocent human life, liberty, property. The rights are in that order. It is our duty to protect innocent life. And, that's just the way I process that issue. I know it's not what everyone thinks or feels. But again, I think you brought up some interesting points in your comments, and I just wanted to kind of add to that because I do think it's things that we have to consider in such a serious matter.
Mr. Chair, I fully agree with you, absolutely, and I and are a one voter, one issue voter representative. the pro-life champion certainly is sitting in the center, at the top of this podium. That said, where, how do we get to that end result is where my issue lies. Is, are we being deliberative enough? Are we sort of ironing out the kinks well enough to make sure that a lot of the consequences than we do, and problems than we're trying to fix? And so, I am, in hearing your impassioned perspective on this, is what I oppose your efforts on this. I want to stand with you, but I won't get in your way. And so what I'll do is I will, again, show my cards, and for transparency, I won't vote against it, but I cannot vote in favor of it. That I am acting in good faith as well, to also represent the people and their wishes as I see it. And, just one point, I want to put an exclamation point on one thing. In your response to me is certainly understood. I hear it and I believe every syllable of it. However, and I'm not sure if I expressed this to you, to campaign and everything, and I went into every neighborhood you could think of: rich, poor, white, black, brown, affluent, not affluent, you name it. And abortion. And I tried to bring it up on several occasions, and it just wasn't something anybody was interested in. Not in the fact that, the heavy emphasis in my district, and you can look at the demographic, the voting registration makeup and everything else, and our districts are very different. And so, I have to call it as far greater areas than just our district. But the feedback I've gotten since then, almost, though we haven't had the discussion, I think that's my point is that I believe that many from the pro-life right all the way to the sort of moderate liberal sort of are standing in unison on this one, in opposition. And that's not to impugn intentions or even the ability to maybe move this thing into committee and again have that more robust conversation. But the about it, because there seemed to have been no real interest in the folks I was speaking with to pursue it as currently, but also understanding that down the road maybe we will. This isn't a period exclamation point at the end of this effort. I see it as a step towards we got here incrementally, and I think we get out of this incrementally. And I think so. This bill, why the sort of universal opposition, is that it's such a great departure, much more greater departure than what the average South Carolinian, the vast majority of the average South Carolinians are willing to stomach. And that's where I say we have to push that envelope all the way up to the line of what we can get through. As one of my dear friends, former Representative Stuart Jones, used to say, I would rather have a 99% bill that passes than a 100% bill that don't. And that's sort of where my heart is on it. And so in good faith, stated my position, and I'm not going to take any more time, but I do appreciate what you're doing here.
Well, thank you for your candidness. Is there anyone else who wishes to be heard before we vote? All right, so I need a motion. I will offer a motion. For a favorable report to the full committee. Is there a second? second from Senator Fernandez. Okay. All those in favor, please raise your right hand. Okay. And all those opposed?
What's the count, Mr. Chairman? I couldn't hear it. What's the count?
2 in favor.
2 in favor.
3. 3 against. Motion of 3 to 2. The